What happens if you die without a will? Your assets will get split per the intestate laws. As an example, in Georgia, your assets will get split evenly between your kids and your surviving spouse, with your surviving spouse getting a minimum of 1/3 of your assets. Now, it's very likely that you want your spouse to get all of your assets when you pass away so that they can take care of themselves for the remainder of their life. If you don't have a will or a trust set up to give direction on your assets needing to go to them, then they will get split up per the intestate laws, and your kids will get a portion of the assets that you intended to go to your surviving spouse, potentially making it harder for them to take care of themselves for the remainder of their life. Now, there are a couple of ways that you can get around this, so we're going to talk about how to avoid the probate process and make sure that your spouse gets all of your assets, and then we're going to talk about how the probate process works when you do pass away without a will. And so in terms of avoiding the probate process and making sure that your spouse gets all of your assets, we have a couple different options. We can do a will, we can do joint tenancy rights of survivorship, or we can do a revocable trust. With a will, your assets can have direction to go to your spouse when you pass away, but they will still have to go through the probate process, which can take 1 to 2 years, depending on the complexity of your estate, before they take over the ownership when you pass away. The other option is going to be a joint tenancy rights of survivorship, which is used on property. So if you co-own the property with your spouse as tenants in common, your half of the property will have to go through the probate process before it can be distributed out to your spouse. Again, having to go through the probate process can take a long time before they take over the ownership. If they need to sell the house for any reason, they won't be able to until the probate process is over. So you can set up the ownership with them as joint tenancy rights of survivorship. Your half of the property will automatically avoid the probate process and go directly down to them. When you pass away, all they have to do is file a survivorship affidavit and your death certificate, and the county clerk's office will process those documents and transfer ownership to your spouse. The other option is going to be a revocable trust. This is if you want to hold all of your assets inside the revocable trust, keep them inside of the revocable trust when you pass away to be used to take care of your surviving spouse for the remainder of their life, and then distribute those assets out to your kids when they pass away. The real benefit of the revocable trust is going to be that you avoid the probate process with your assets 2 times: when you pass away, and then when your spouse passes away and you distribute those assets out to your kids. Now, the probate process again takes 1 to 2 years and can cost $5,000 to $15,000. So you're saving your family a lot of time, money, and headaches when you set up the revocable trust. Again, also a side note here is that most people who are setting up the revocable trust are the ones who handle the finances. When you pass away and your surviving spouse has to take over the management of those assets, it's typically going to be difficult for them, especially at the end of their life. So the revocable trust allows one of your kids or a trusted family member or something like that to take care of those assets on behalf of your spouse, so they don't have to worry about figuring out how to manage your assets. Side quest there. Now, in terms of what the probate process is like when you do die without a will, you're going to go through the probate process and your assets will get split per the intestate laws. But the process is this: when you pass away, the person who's going to be the administrator of your estate, it's going to be a first come, first serve. Whoever wants to do it, they will go get your death certificates. They will file the death certificate along with a petition for probate at the local probate courts in the county where you lived. The courts will open up the probate process, give them the letters of administration, which allows them to have the authority to take over the management of the assets in the estate and manage the probate process on behalf of the estate. So what they're going to do is go to your banks where you had all your money, your institutions where you had your investments. They're going to go to the utility company, etc., and they're going to show them the letters of administration and take over the management of those assets that you had. And then they're going to move all of those assets to the estate. So they're going to open up an estate bank account, move all your money into the estate bank account, start making payments on your utilities, mortgages, etc., during the probate process with the money out of the estate. Then they're going to publicly notify creditors that you have passed away. Those creditors are going to come to them and say, hey, this individual owes us money for these debts that they had with us. They will take the liquid assets inside of your estate to pay off those debts. That would be things like your checking account, investment accounts, etc. If there are not enough liquid assets inside of your estate to pay off those debts, they will start selling off physical assets to pay those debts off. This would be things like cars, homes, boats, etc. And then if there are not enough assets inside the estate to pay off all of the debts, it can literally wipe out your entire estate and all of the assets inside of it, leaving your family with nothing. Now, if there is enough money inside the estate to pay off those debts and then there's assets left over, The remaining assets will get distributed out to the beneficiaries per the intestate laws, since you do not have a will. And so again, the intestate laws are going to vary per state, but in Georgia, the spouse and the kids split those assets evenly, with the spouse getting a minimum of 1/3. And so the administrator of the estate will have to distribute those assets out accordingly to the intestate laws. That's how the probate process works. If you want help with the probate process, or you want to set up your assets to avoid the probate process and make sure your spouse is taken care of when you pass away, click the link in the bio, fill out the form, and schedule a time to talk to some of our team.